In regard to letters and testamentary, administration with the will annex be thereupon issue a revocation of such first letters of administration shall be made by the surrogate, and until the same be made and served on such first administrators. This act done in good faith shall be valid. 25 S. L. 1837, Chapter 496, S. L. 1862, Chapter 229, 3 R. S. 5th edition, 163. When any person interested in the estate of the deceased shall discover that the sureties of any executor or administrators are becoming insolvent, that they have removed or are about to remove from this state, or that for any other cause they are insufficient, as when the estate is discovered to be larger than at first supposed. 35. Such person may application to the surrogate who granted the letters testamentary or of administration for relief. 26. If the surrogate shall receive satisfactory evidence that the matter requires investigation, he shall issue a citation to such executor or administrators requiring him to appear before such surrogate at a time and place to be therein specified, to show cause why he should not give further sureties or be superseded in the administration, which citation shall be served personally on the executor or administrator at least 6 days before the return date thereof. Or if he shall have second or cannot be found, it may be served by leaving a copy at his last place of residence. The executor, administrator, or guardian cited to show cause why he should not be superseded may also be enjoined by the surrogate from further action until the matter of controversy shall have been settled. S. L. 1837, 535. If on the return day, on hearing the proofs of allegation of the parties, the surrogate shall decide that the sureties are for any cause insufficient, he will order the executor or administrator to give further sureties within 5 days. And if he neglect to comply with the order, his letters will be revoked. S. L. 1837, Chapter 460, S. L. 1862, Chapter 229, and 3 R. S. 5th edition, 163. Where the practitioner swear to the interest, the surrogate will not try an issue upon that question, etc. W.M. H. Merchant, 1 Tucker, 17. When either or all the sureties of any executive administrator shall desire to be released from responsibility on account of future acts or default of such administrators, they may make application to the surrogate who granted letters to the administration for relief, who will thereupon issue citation to the executor or administrator to appear before him or give new sureties in the usual form within not less than 6 days. In regard to letters and testamentary, if such executive administrator shall give new sureties to the satisfaction of the surrogate may thereupon make an order that the sureties and sureties who apply for relief in their promises shall not be liable or their bound for any subsequently act, default, or misconduct of such executive or administrator. If such executor or administrators neglect to give new sureties, his letters will be revoked. 32. And any remaining executive administrators whose letters are not revoked will have full power to do any act necessary in the administration of the estate. Whenever it shall appear to the surrogate that letters of the administration or letters of the guardianship have been granted on or by the reason of false representation made by the person to whom the same were granted, and also whenever it shall appear that the administrator or guardian has become incompetent by law to act as such by reason of drunkenness, improvidence, or a want of understanding, the surrogate shall have power to revoke such letter. The revocation may be made when issued on false representation, even when they were made not fraudulently but by mistake. Paley versus Sands. Third, Edwin chapter 325, Proctor visit Ransmaker, 1 Bob, each 302. See also Carey v. Carey 41, New York 272. Whenever an absent or non-resident executor or administrator shall have been duly served with a citation to account and shall, without reasonable cause, neglect or refuse to appear in pursuance thereof, the surrogate may, in his discretion, revoke the letter to such executor or administrators. The surrogate of the County of New York may revoke the letters of executive administrator or collector or testamentary trustee or guardians upon their own application for good cause shown, and on notice to the person in interest, and may make such terms or conditions for the security of the estate as in his judgment are required. After such revocation, the surrogate may issue letters to the administrations, letters with the will annexed, or a collection of appoint of successor to such trustee or guardian. SL 1870, Chapter 359, 47 2RS 79 3RS 59 165. All sales made in good faith and all lawful acts done, either by administrators before notice of a will or by executive administrator who may be removed or superseded, or who may become incapable, shall remain valid and shall not be impeached, or any will afterward appearing, or by any subsequently revocation or superseding of authority of such executors and administrators. 53. Of the duties and executors of administrators in regard to the inventory and the rights of the widow and the minors. The duty of the executors and administrators to take an inventory, although too often neglected, is highly important and importantly directed by a statute. There are very few cases in which it is consistent with the most common prudence to neglect taking an inventory. It may not be necessary in all cases to file it. 2 John chapter 1, chapter R62. The surrogate granting letters shall, upon the application of any executors and administrators, appoint 2 disinterest appraisers as often as occasions may require to estimate and appraise the property of deceased person. 2 RS 82, 3 RS 5th edition 168, see order in appendix. The appointment is made by the surrogate, and he usually consults the desires of the parties as to whom to appoint. The duty of the appraiser being to fix a value to charge the executor or administrator as between him and the next kin. Legatees, it is very proper rule to appoint only those who could act as jurors in a trial at law in which any of those parties may be interested. 2 or more inventories may be made if necessary. 3.2 RS 82, 3 RS 5th edition 169. A notice of such an appraisement shall be served 5 days previous thereto on the legatees and next of kin residing in the county where such property shall be, and it shall also be posted for the same time in 3 of the most public places of town. See form notice appendix. And it is very proper, although not required by law, to attach proof of such service and posting to the inventory file with the surrogate. The appraiser shall, before proceeding, execute their duties, take the subscribe and oath, see form of inventory appendix, to truly, honestly, and impartially appraise the personal property which shall be exhibit to them. After the first meeting, they may adjourn from time to time, as may be necessary. It being the duty of the executive administrator to exhibit the property to the appraisers, he may well spend some time in arranging it in classes before meeting to facilitate their labor as well as to learn the extent of details of the property for himself. Thus, he may arrange the notes in one class, bonds and mortgages in another, farming, implement stock on a farm, furniture in other classes.